Let's talk about that Hawk Tuah trademark. I'm Angela Langlotz, trademark and copyright law attorney. I go live here on weekdays to talk about trademarks and copyrights. If you have trademark and copyright law questions, drop them into the comments below. I'll answer them on a future live. So today I want to talk about a funny viral video that has gained a lot of traction, and so much so that people have applied actually to register the famous phrase that was uttered during this viral video. I'm talking about the Hawk Tuah and spit on that thing video that went viral last week. So how do you how do you get a trademark for something like that, a phrase that's gone viral? Well, recall, we can apply for a trademark for anything so long as it's distinctive for the goods and services for which we're applying to register. So in this case, let's remember that you don't actually acquire trademark rights until you actually use the trademark in commerce, but you can sort of hold your place in line by filing a trademark application on your intent to use the mark in commerce. And that's what a few people here have done. When you apply based on an intent to use the mark in commerce, the first person to apply, this is assuming that nobody has actually used the mark first, the first person to apply is the one who actually has the better trademark rights. So I'm going to shrink myself into the corner and let's go see who's applied for what. So here are all the trademarks that got applied for. There are 8 of them, and you can see they've applied for things like hats, stickers, sauce mixes, put some spice on that, I guess. Oils and lubricants. I will refrain from further comment. Retail store services featuring coatings. I'm guessing probably in the nature of lubricants, but I won't click on that because I don't want to get distracted. And then these are shirts and preparing promotional and merchandising. This is the wrong description for that, but the trademark office will take care of that later. So 2 people have applied for clothing. This woman, Alicia Mack, hats, shirts, sweatshirts, hooded sweatshirts. If anybody knows her, go ahead and tag her. She's in this video. And then Show Me Outfitters LLC, a Missouri company, they've applied for shirts, right? So who has the better rights? Let's go have a look. So who applied first? They both applied on June 19th. Look at that. So they both applied on June 19th. How do we know who has better trademark rights? Well, all we have to do actually is look at the serial number to see who applied first, because every trademark application gets a serial number. So the lower serial number, that's this one right here, 9011, will win sort of the trademark first to file battle. This woman's serial number ends in 9480, so she came last. So whoever applies first and then actually shows their use of the trademark will win this trademark priority battle. So what about their trademark rights now, though? Don't they maybe have some trademark rights? Well, maybe they do. They might. They might have some what are called common law trademark rights, which you can acquire based on your use of the trademark in commerce. However, remember that trademarks have to be distinctive, not merely something that you're trying to say is a trademark. So trademarks must be seen by the consumer as a trademark, as a unique source identifier for your goods and services. And if you can't show that, the trademark rights are going to be hard to assert, right? So if you say, oh, you can't use this is my trademark, and everyone's like, that's not a trademark, that's just a viral phrase from a video, a silly video that everyone has been sharing around the internet, that's not a trademark, you're going to have a hard time enforcing that because your audience doesn't see that trademark, that phrase rather as a trademark. So you're going to have a hard time enforcing your common law trademark rights, and you're going to have a hard time because you don't yet have a registration. How long is it going to take you to get that registration? Well, potentially it will take you probably about a year for the registration to be issued. What happens by then? Well, who knows, but we've probably all moved on from Hawk Tuah, or however you want to say it, spit on that thing. We've probably all moved on from that. So why bother to apply for a trademark application for this? No idea. It's just somebody thinking that they can obviously monetize the viral nature of that video. Let's look at a couple other things, though, that I think are more creative uses for the Hawk Tuah, spit on that thing phrase. Let's go have a look. So this person right here has applied for personal sexual lubricants. Now, that is actually something that is congruent with the original, we'll just say, Hawk Tuah discussion that was being talked about in this video. So I can see that being sort of congruent for that phrase, let's just say. And then someone else has applied for body lubricants. Who's going to win? Well, again, who applied first? Let's have a look. The first person, personal sexual lubricant person, serial number 4265. That's the ending. This person, 4481. So they lose. But here's the interesting thing. They both applied on the same day. So why didn't person number 2 know about person number 1's trademark? Well, the reason why they didn't is because when you apply for a trademark, there is a couple days, I call it the gap, right? Capital T, capital G, the gap. There is the gap during which applicants can't see what came before for a couple of days, right? Might be 3 to 5 days. So if somebody is applying on the same day, they won't have any knowledge at all of the previous applicant's application because they can't see it. It hasn't shown up in the trademark database yet. And the reason why it hasn't showed up is because when you apply, there's sort of a preliminary screening of the trademark applications just to make sure they meet certain basic thresholds of processability. And if your trademark doesn't meet that, they'll just kick it out. They won't assign it a serial number. The fact that both of these have serial numbers means that they've at least met the minimum requirement for processability, and that's a good thing. But sadly, person number 2 didn't know about person number 1's trademark application. So what will happen is they will get a notice that says, hey, we've looked at your application and unfortunately there's somebody else who applied before you did. And so that somebody actually has place in line, they have priority, we say, before you. But if this person doesn't actually show use of the trademark eventually, then they will actually lose their priority and you will have priority. So this applicant number 2 is sort of stuck in limbo until something happens with application number 1. That's either it goes abandoned for a lack of statement of use or it issues as a registration, in which case the trademark office will tell the person number 2, sorry, we're not going to issue your trademark registration because there was somebody else that applied before you for similar goods and services, and we issued them the trademark registration instead. Now, how long can this limbo last? Well, this limbo can last up to 3 years after the notice of allowance. The notice of allowance is the trademark office telling the applicant, hey, we looked at your trademark. We didn't see any problems with the application itself. Nobody else is using something similar. So you can go ahead and show us your use now. Then the applicant has up to 3 years after the date of that notice to actually submit their proof of use of that trademark on the goods and services that are mentioned in the trademark application. If they don't do that, at least pay a fee and extend that time every 6 months for up to 3 years. If they don't do that, the trademark application will go abandoned and person number 2 now has priority. So it's kind of an interesting situation. I had to do a video about it because we're all talking about it and there are trademarks on the table in play. I'm Angela Langlotz. If you have trademark and copyright law questions, drop them into the comments below. I'll answer them on a future live video. Don't forget to like and subscribe to get all of my new trademark and copyright videos.